Hi, everyone, and welcome to this very special live episode of Let's Talk Bitcoin. Today, we're going to be talking about the DAO, about the fork, and about the fallout. We're going to have a number of guests on the show. Pamela Morgan, attorney, is joining me right now. And then we're also going to have a number of other guests joining a bit later in the show. For questions and answers, please use hashtag LTBDAO on Twitter. I'll be watching that. Talk to me in the DAO Slack or comment directly on the YouTube channel. Again, for questions, hashtag LTBDAO, use the YouTube comments or the DAO Slack. I'll be watching all of those and asking the questions from all of our guests. First, let's say welcome to Pamela Morgan. Pamela, welcome to the show.
Thank you so much. I'm really happy to be here today.
So we're going to do some quick disclosures. I am a DAO token holder. I hold a whopping $40 worth of DAO tokens, which I purchased in order to be able to participate as a DAO token holder in the process and learn from the DAO. I did that in the early days, purchased it directly during the pre-sale or the funding phase of the DAO. Also, I am the Chief Technology Officer for Third Key Solutions, and Pamela Morgan is the CEO of Third Key Solutions. And we have submitted a proposal for discussion, not for funding, but just for discussion, to the DAO forums. And this proposal is called the Decentralized Arbitration and Mediation Network. That proposal received a lot of comments, a lot of discussion. And what we were talking about there was the intersection of law and DAO. So that's just a mandatory disclosure, just to say that we have a lot of interest in this project. We've been interested from the very beginning in how this project would play out. We do not have really a financial interest in this project, just a geeky interest in this project. Pamela, tell us a bit about how you first got involved with the DAO while I set up my Twitter keyword, LTBDAO, hashtag LTBDAO for questions on Twitter.
Sounds good. I actually have to do a few disclosures myself as well. One, I do not hold DAO tokens, but I have written articles about the DAO, specifically about how interesting it is and what an incredible experiment it is. And no matter what you think about the DAO, whether you're pro or anti or somewhere in the middle, I really think that what's happening right now is absolutely fascinating. And I think we're making history. I also need to do a disclosure, the compulsory, I am a lawyer, but this is not legal advice disclosure. So we will be talking about the law in broad terms, but this should not be construed by anyone watching or listening now or in the future to be legal advice. So basically, we're going to talk about the law as it applies to the DAO, or as it might apply to the DAO, because we'll learn as we get into these discussions that really nothing about the DAO is cut and dry. Nothing is known.
All right, that's a great introduction. So let's dive right in. So the DAO, the Decentralized Autonomous Organization, the first of the decentralized autonomous organizations created by Slockit. And this DAO raised about $150 million during the fundraising process. That's in Ether. And of course, based on the fluctuations in Ether, that went up as high as, was it about $230 million in total? So quite a bump there. And now it's also had quite a significant drop in value. 2 days ago, I woke up to find out that there was an event in progress. Now, we'll talk about exactly what kind of event this was. You know, some people have jumped into using the term theft. Some people have used the word hack. Certainly, it's hack in the traditional concept of the word, the traditional etymology of the word hacking, where you hack to learn, you hack to understand how code works. Whether it's hacking in the malicious hacking sense, we'll have to figure out next. But an event happened, and the DAO was basically drained, or a very large amount of funds, about a third, 3.5 million Ether, was leaked into a split proposal to a split DAO. And this precipitated an enormous amount of drama. As someone who comes from the Bitcoin space, I can tell you that drama is something that over the last 5 years we're well used to. But for those who are new to the Ethereum space, where scaling problems don't exist, where governance problems don't exist, and when everything's hunky-dory and everybody's happy, this was probably the first instance of some quite serious amounts of drama. So when did you find out about this, Pamela?
This incident,
Mm-hmm.
or the DAO overall?
Well, both, really.
Yeah, I mean, I've been watching the DAO from the beginning. I've been. Is that a beer?
Yes.
Fantastic. I wish I had one.
I think with a topic like this, it's kind of required, right? So.
Yeah. Or afterwards. Anyway, I've been interested in DAO, or decentralized autonomous organizations, or DCO as they're sometimes called, distributed or decentralized collaborative organizations. And there's all sorts of acronyms. And, I've been at nerd fests at Harvard and MIT, and we've been talking about what the appropriate acronyms are. And we've been talking about legal issues surrounding the function of DAO, or what they're known today as DAO. And so I've been interested in this from very early on. But this situation, the situation with the DAO, very quickly raising this amount of money, has been on the radar, not only for me, but I think for everyone else as well. And I learned about this incident probably at the same time most other people did, which was a couple days ago. And it's been not a lot of sleep, and a lot of thinking, and a lot of talking to a lot of people ever since.
All right, let's start and talk about some of the details of what exactly happened in this particular event. So first of all, the hack itself. Now, in this particular case, the issue was literally one line of code.
Which is just like legal contracts. These are the same exact issues that come up in your traditional legal contracts, where one word or a sentence changes the outcome completely, where there are unintended consequences, where someone writes a sentence and it makes perfect sense to them, and they think that they're on the same page with the other party, and then all of a sudden, the other party either uses that sentence to their advantage, or it's just a mistake or a misunderstanding. So this isn't a stranger for us in the legal profession, although I think it's come as quite a shock to those who are participating in the DAO, and it's quite unfortunate how this is playing out for them.
Yeah, absolutely. So what were people really signing up when they signed up to the DAO? I think that's one of the critical questions here. What are the terms and conditions of the DAO? I think that was one of the really fascinating revelations when you read the white paper or the DAO Hub forums. The terms and conditions said, and I'll quote it in a second. I'll pull it up and quote it for you in a second. But essentially, they said, don't pay attention to the white paper. Don't pay attention to the website. All of these are just plain English explanations. The contract is the code, and the code is the only contract. And if there is any conflict, what the code does is the authoritative issue. Where does that put us, Pamela?
You just asked about 1,000 questions rolled into one, and you did it quite well. Have you ever written law school exams?
Mm-hmm.
Because these are the types of nuanced questions that come up. First of all, let's get one thing straight. Just because we say something in writing, just because we say that other laws don't apply, does not mean that other laws don't apply. I wrote an article, I don't know, probably a year ago now, maybe a year and a half ago, called Arial 11 and Default Law. And there's this concept in the law where if you don't say something otherwise, there will be a default law applied. So in this case, the quote unquote parties, if we assume that there's a contract, and I can't even say that there's definitely a contract, there's room for interpretation. If there was a contract, there are something called equitable remedies. And for those of you that are listening or watching who come from common law countries, if you've heard of the term common law, equitable remedies are part of common law. And I know I'm using legalese right now. Equitable remedies simply mean somebody got shafted and the court is going to make it right. And they're going to make it right based upon equitable principles. And there's lots of these in the law. But basically, just because the code itself says this is a contract and these contain all of the terms of the contract does not mean that a judge will interpret that as the only terms in the contract. Does that make sense?
Right, absolutely. And the issue really here is that we also have a statement purported to be by the initiator of the split that drained funds from the DAO. And in this, I don't know what to call it, open letter, I guess, in this open letter, actually signed quotes the attacker because that's what other people were calling this person. And this person says that they use the code as a contract, and the code allowed them to gain reward, and therefore that is perfectly fair within the terms of the contract, and that in fact trying to remedy or undo that would in itself be a breach of contract. But we'll get to that in just a second. I think first we need to describe exactly what the hack was. Would you agree we should dive into some technical stuff here?
Absolutely.
All right. So the issue here is called reentrant code, specifically a race condition created when a function that is called in the DAO causes like a loop where it gets called again and again and again before it has a chance to complete, creating a nested stack of calls, all open but none closing. In this particular case, someone initiated a split proposal. This type of split proposal is something that could be done from day one after the funding process completed. And the goal of a split proposal was to allow people to refund their DAO tokens if they wanted to get out of the DAO. Someone initiated a split proposal. Now, in the code specifically, for transferring the reward once the split proposal vote has ended, there's a call to a contract, and then the amount of reward tokens that have joined the split and belong to each user are transferred to that contract with a value call, which is basically a transaction that contains a certain amount in Ether. Now, in this particular case, though, the one error in the code was that first the function was called, and then the internal ledger that the DAO or the child DAO was keeping of the balance of DAO tokens was updated. But when you call the value function of another contract, it can catch that call as an incoming function. This is the function with no name, just brackets, right? Which basically means if you have any transaction that's incoming and is not calling a specific function name, but just contains value in Ether, if you have a value call coming into the contract, execute this code. And so the child DAO from the split proposal would call the value to pay out the contract. And that contract would in turn call the release reward or send reward function again, which would call the recipient contract with a value call, which would once again call the reward function, which would call the value in the child contract, et cetera, and it never got to the line where it updated the balance. And so as a result, every time it entered that call, it would transfer ETH to the reward recipient without ever exiting from that call and updating the balance. An easier way to explain this is, imagine if you have an ATM machine, and the ATM machine is structured so that it gives out the money, and then once the little counting machine that pops out paper bills at the bottom has counted and confirmed the bills and popped them out of the slot, it then updates your bank balance after the fact. Now imagine if there was a way to jam the door so that whenever it popped out money from the bottom, it would then crash the ATM so that it gave you money, didn't update the balance. You run it again, gives you money, doesn't update the balance. Gives you money, crashes, doesn't update the balance. And essentially that's kind of what happened here. And what this did was that every time a block would be mined with this transaction to distribute the reward from the split proposal, it would call this function again and again and again and again without ever getting to the next line in the code that actually updated the balance. Now, this can be fixed in a number of ways. One, you can update the balance first and then give it out. Or you can set up what's called a mutex, which is a concurrency mechanism, essentially a lock that ensures that the code is not reentrant. This type of situation where you have concurrent programs stepping on each other is called a race condition. And so this person was able to, I don't know if I should use the word exploit, perhaps that's an appropriate word, exploit code as it was in the contract to repeatedly drain Ether from the DAO into this split proposal and into their own contract address. So that's a rough summary of what happened, and that's the DAO hack or the DAO exploitation.
Let me jump in with just a bit of legal context here as well. So there are a lot of questions on what the DAO actually is from a legal perspective. But many in the industry, including myself, say that it's most likely to be interpreted as a general partnership. What does that mean? Basically what happens, we're back to that default again. So if you start a business, being if you join with others for a specific purpose and you are attempting to gain a profit, which arguably that's what was happening in the DAO, if you don't choose another formal legal vehicle, like a corporation or an LLC or a limited liability partnership, you will be considered a general partnership. And what that means, that has a lot of legal implications. And interestingly, in the United States, general partnership law is state by state. So there isn't one federal rule that applies to all states in the United States. There are guidelines, and some of the states have adopted similar laws. But basically what this means is that, if one of the members of the DAO wanted to bring a legal action, they could argue that they were a general partner of the entire DAO and essentially do something that's called forum shopping. Have you heard of forum shopping before?
That's where you arbitrage jurisdictions in order to find the most suitable one?
Absolutely. And because the DAO did not choose a formal structure, arguably any jurisdiction where a general partner is located could be proper jurisdiction for the DAO as a whole. Now, general partners have full liability for one another, but they also have a duty of loyalty to one another. And for this duty of loyalty, there are 3 different duties that you have built up as part of this duty of loyalty. But the important one, for our purposes, I think, is as a general partner, you have a duty to refrain from dealing with the partnership as a party having an adverse interest to the partnership. Basically, that means that you can't take self-action that is inconsistent with what would benefit the general partnership. And
So I think that if I understand this correctly, and I think we need to clarify this, this hack, or whatever you want to call it, happened by someone executing a split proposal from within the DAO. This is not something that any passerby can do, just snipe the DAO. They have to be a DAO token holder in order to execute this. They need to have the ability to vote. They don't need a lot. They just need enough to create a split proposal. And that's it. So, but the important thing is that this can only be done by a DAO token holder, either someone who bought during the funding process or someone who acquired DAO tokens in a secondary market, because some time elapsed between the funding process and when this was initiated. Someone could have bought this on a secondary market. And therefore, by owning DAO tokens, what you're saying is, as a partner in this general partnership, they have a duty to the other members to not take actions that are adverse to the overall DAO.
Exactly. That's part of their fiduciary duty as being one of the general partners. Partners also have a duty of good faith and fair dealing. So but again, this is only in relation to general law in the United States.
This could be whatever. I mean, you could pick Tuvalu and find some obscure law that says it's called the general partner fuck you clause, where they can do whatever they want.
Exactly.
And it's to Tuvalu, and all they have to do is find one DAO token holder there in order to claim jurisdiction in that form.
Yeah, I mean that's the difficult part of not either, well, selecting a corporation, LLC, something like that, but also, these sorts of risks could have been mitigated if there had been terms and conditions in the DAO that designated a choice of law and a choice of venue. So
even if that was not a national jurisdiction, but as we have described in this, where we show our bias, but specifically in the concept of a decentralized arbitration system, the venue could be a private arbitration forum that is not national law.
Absolutely.
Or it could be a national jurisdiction, but not picking any means that you're not getting arbitration by private. You're not getting resolution by private arbitration. You're not subjecting yourself to that jurisdiction. You're not subjecting yourself to any specific jurisdiction. But as a result, you're subjecting everyone to every jurisdiction.
That's correct. And let's quickly talk about arbitration and why this matters. I don't want to stay here too long, but it's something that everyone in this industry should be taking very seriously, especially because it's really easy to do. The American Association of Arbitrators, also known as AAA, and I think their website is adr.org, but we can post it later, actually has a clause creator where you can create your own clause and you can say, okay, I want any disputes to be governed by Delaware law. Delaware is often chosen because it is corporation friendly, but you can pick anything you want. So you can say, I want all disputes to be handled by Delaware law.
Or Uniform Commercial Code?
Or, yeah, I mean, I suppose you could do Uniform Commercial Code. Or you can have your own industry rules, which is really, really interesting, and hopefully at some point we'll get there. But for right now, we can apply any laws and rules that we want.
This is not about selecting state enforcement. This is about, in many cases, simply opting out from state enforcement and, in fact, setting up complete rules of private jurisdictions with private enforcement and private rules of our own design.
Yes, and in this instance, that's important because not only do we not know how the DAO is going to be interpreted, but we don't know what laws are going to be applied to the claims that are being made. In other words, if I bring a breach of contract claim here in Chicago, we can tell that Illinois law is going to govern that contract. But if you bring a breach of contract claim in California, breach of contract may be different in California. If we bring one in South Africa, somewhere in Johannesburg, for example, the breach of contract law may be very different. Remedies may be very different. And so right now, as you aptly said earlier, we are exposed to all jurisdictions where if we use just simple terms and conditions and limit the jurisdiction, then we get that certainty, and then at least we can better protect ourselves from the inevitable unintended consequences and unintended lawsuits that will arise as we do business internationally.
Absolutely, and arbitration is a topic we'll get back to in just a second. I also want to point out we already have two guests to bring on into the, well, I guess we'll call it a show now, because it really is a show. Let's see, Taylor, are you ready to join us here? Let me see if I can pull Taylor in, and we'll continue this conversation.
Hey, Andreas, can you hear me?
Taylor, welcome to this conversation. Yes, we can hear you.
Hi, Taylor.
Hey, Pamela. Great to see both of you again.
So, Taylor, do you want to do a quick introduction of yourself?
Yeah, sure. My name's Taylor Gerring. I have been involved in Bitcoin and Ethereum for about 3 or 4 years now. I started working out on Hive with Wendell Davis, and through that kind of met Mihai Alisi, and through that met Vitalik Buterin, and from there on out kind of got involved in Ethereum, working on a variety of projects there. I'm also a curator for TheDAO, though I don't hold any tokens, which I think puts me in a kind of interesting position. I've been watching and discussing with a lot of people lately, trying to gather opinions and thoughts, and kind of as you guys were mentioning earlier. And it's definitely a hot topic. I think there's a lot we can learn out of it. There's definitely a lot to get through still before we have any sort of hindsight.
And you're a co-founder of the Ethereum project as well, is that correct?
Yeah, that's right. I helped co-found Ethereum Foundation in Switzerland along with Mihai Alisi and Vitalik Buterin, and that allowed us to set up the proper legal framework to execute the crowd sale and have the associated business dealings that we need to just do everyday sort of business, like paying employees and paying for expenses to have an office and have meetings and things like that that are legally required. So. Yeah, the operation's still going. I worked also on the Go Ethereum client with Jeffrey Wilkie, implementing the first RPC layer there. So I have a pretty deep technical knowledge of the software.
Now, were you on when I did my ham-fisted attempt at describing code reentry and race conditions? Is there anything you want to add to that, or did I capture the essence of that at all?
No, I think you captured it pretty well. One of the things I was thinking about last night was, look, this is a problem that could definitely happen in any sort of programming language. Like, think about the first version of Java, right? There were probably ways to code that weren't so probably productive for the programmer. And if we look at this problem this way, like thinking about the distributed consensus layer separate, then how would we have maybe approached this, and how would we have fixed a problem like this? And I think part of that answer is definitely make the tools better for the users, maybe have warnings from the compiler that you're doing something that could perhaps be not what you intended. So I think it's just early. The networks existed for less than a year, so the tools are still a bit raw. Definitely room for improvement in that area.
Now, certainly one of the arguments that could be made, and I made this argument early on Twitter, is that the DAO as a concept had a certain amount of complexity, which surprised me when it was first launched. And then I think everyone was surprised, including the Slockit team that built this code base, at how immense it became in terms of size. That created a tremendously large almost security bounty, vulnerability bounty for anyone who could find a vulnerability to exploit in the DAO, which is a great way to test Ethereum. But in this particular case, maybe over-tested Ethereum, overextended the ability of the code at a point where the maturity of Solidity code wasn't quite there. I know you weren't involved in the creation of the DAO. I want to make that clear. You're a curator, which is an oversight role and had nothing to do with the creation of the code. But would you maybe have considered putting a limit in if you were involved in that code and not raise this much money so soon, so quickly in Ethereum? Yeah,
I think that's a really great point. And one of the things that I think we can take a page from, the Digix token sale. That happened so fast because they did have a cap on it, And here we have a situation where there was no cap and it grew immensely fast. I think in both cases we can see that there's like tons of interest from such a fast rate of people putting their money in, but yeah, I mean, I suppose it does beg the question of, was this smart to leave it totally uncapped? It was, I think, far and above and beyond anything anybody imagined in terms of total value. Just people wanted to pile into this project. I think they saw the value of having something like this for the whole ecosystem and increase exposure for it in that way.
I think there's a risk here of people gloating and kind of expressing this Schadenfreude, this gleeful feeling at other people's misfortune. I think we need to step very carefully to avoid that. First of all, because regardless of the outcome, this was a fascinating experiment in governance, in smart contracts from the very beginning. And I participated knowing full well the risks. I think a lot of people perhaps underestimated the risks in participating on a very large scale. But at the end of the day, this is something that will help us learn a lot about governance. Unfortunately, it's also something that is now costing some $55 million. I don't know what the current valuation is, but it seems to have hurt not just the DAO, but also Ethereum. I remember the night before this event happened, Ether had just hit $21, which gave it a valuation of some 2.7 billion, I think. And today it's hovering around 12. This clearly hurt Ethereum, or at least, not Ethereum, but at least the price of Ether. Fortunately, as we know in cryptocurrencies, if you take the long view and hang in there, things turn around. But you know, I think it's important to not take a position here, and I certainly don't, of saying, you know, this doesn't really show anything about Ethereum, but it certainly gives us a lot of good lessons to learn about building complexity in smart contracts, and whether we're ready for that level of funds to be tied up in smart contracts.
Yeah, it's interesting. I do agree. We have to be very careful and think about what precedents are set for the future and how we might learn from any missteps we've had. You know, looking back in the entire history of crypto, there are lots of mistakes been made, but we can always learn from them. And I think governance is certainly one area that needs more attention and improvement. You know, when we have difficulties in our communities, we have to figure out how to work past them for the betterment of everyone. And this is an opportunity to kind of do that in a really positive way and try to come out ahead with the whole community. And hopefully we can still do that. It's going to take some time, I think. Fortunately, some of the delay built into the withdrawal of the funds of the DAO gives us time to discuss. So that was a very intelligent design decision made by the implementer of the code. But hopefully we can come up with a decision soon here and look forward to better governance.
So I think that's a good point to switch topics and talk about the cure that might, in fact, be worse than the disease. The DAO was our first topic. The second topic is the fork. And here we have to take, I think, a very skeptical and careful look at the proposed remedy to this event, the fallout from that, and what happens next in both the DAO and in Ethereum. Pamela, what do you think are the implications of the proposed remedy, at least from a legal perspective? In the meantime, I'm going to bring in our next guest. Stand by, everyone. Pamela, tell us what you think the implications are.
Well, let's start out with first, it is impossible for anyone to know what the implications are because we don't know what law applies and we have no idea what jurisdiction we'll be in. But, you know, I think that when we're looking at this fork, there are some really, really interesting questions that arise. I think, first of all, and I thought we were going to read the quote-unquote attacker's paste bin article. I don't know what you call it.
The open letter?
Yes, the open letter.
Yeah.
But while you're getting that, I think it's important to note that this person is legally savvy. And we could go through the letter line by line, but I think it's interesting the way that they phrased certain things. And to me, when I read it, it seemed very clear that they were trying to assert, for example, this was not a mutual mistake. So the first line starts out by saying...
Let's go in and actually read that, but first I want to briefly introduce our next guest. I'll talk a bit about the proposed remedy. Brian, welcome to the show. How are you?
Great, welcome.
Welcome,
Can
Brian.
you hear us well?
I can hear everybody.
Great. Do you want to do a quick introduction?
Sure. My name is Brian Klein. I'm also an attorney like Pamela. I represent a lot of people in this space. I do criminal defense and civil litigation. I volunteered as the outside general counsel for the Bitcoin Foundation for a little bit. I represented people like Eric Voorhees and Roger Ver and a number of companies and other individuals. So I've been pretty active since 2013.
Right. Welcome to the show, Brian. So first let's talk about the proposed remedy, and then we'll talk about the alleged response letter. We're going to have to be very careful about whether we attribute authorship to the so-called attacker on that. You know, we don't want to be Craig Williams in this particular case. You know, there's the idea of having false identity in this space is a big issue in how you verify identity. Sorry, did I say Craig Williams? I meant Craig Righted. We don't want to be Craig Righted. So let's first of all talk about the proposed remedy. Proposed remedy was posted by Vitalik Buterin, the creator of Ethereum, who at a very early time of the day got together with a lot of the other Ethereum developers and the exchanges and tried to put a plan into action to fix this problem. Now, this in itself has caused a lot of consternation among many people because they, perhaps rightly so, see this as an intervention in the operation of a smart contract. And you have this cognitive dissonance, this seeming contradiction between the idea that the contract is the law, the contract stands on its own, it floats above jurisdictions, it is self-executing and subject to no human interference and oversight unless, of course, we fuck it up really bad, in which case we call Vitalik, and Vitalik fixes everything for us, which is a very dangerous precedent, because now we've gone to the other side. Now, of course, even Vitalik can't fix this because Vitalik doesn't control Ethereum. Nobody does. So all Vitalik can do is beg the exchanges to stop trading for a while to give it some room to breathe, and then propose this soft fork. But of course, that, again, does not get executed unless you get consensus for the miners, and that's where the drama starts. Now, I want to go specifically and look at the proposal. Vitalik suggested that a soft fork be activated that immediately, let's say, immobilizes the funds in situ. It's basically like putting a freeze on the funds. And the specific proposal for the contract was, which has already been implemented by Gav Wood in Parity, is to put a freeze on contracts with a specific hash code and not allow any transactions that withdraw funds from those contracts. That would protect the DAO. It would protect the child DAO. It has some rather disturbing side effects on other DAOs implemented using the exact same bytecode. And this is stage one. This is the freeze. And stage two that was proposed and has now been withdrawn from the backlash, we saw that specific sentence in the Ethereum blog disappeared overnight tonight. There was one more sentence in the proposal that said to be followed by a hard fork to refund the money to the DAO holders. That's gone now. We don't know if it's going to be followed. So let's call it the freeze followed by the seize. So we're talking about freezing assets followed by asset forfeiture. This isn't a bailout, and I think people rightly so have said, listen, this isn't a bailout. No new ether is being created. This is not a Ben Bernanke moment of Vitalik Buterin bailing out the DAO. It's the same amount of ether. It's simply undoing a specific theft. That's what it's being called. But whether it's a bailout or not, it's most definitely asset forfeiture. It's asset seizure the moment it's being frozen, followed by asset forfeiture done through a majority vote consensus mechanism. So we're basically saying that the majority can do asset seizure followed by asset forfeiture through the consensus mechanism. Pamela, your thoughts on the legal implications?
Of seizure? I'll say I think it's a bad idea. Sorry, I'm having some echo. I'll say that I think it's a dangerous idea, and I just want to speak to this from a legal perspective for a second, in that these decisions that are being made by Vitalik, by developers, by the miners, they're the same sorts of decisions that are being made by judges. And the question is, what is the remedy? How do we make people whole, and who is going to bear the risk of loss? Right now we're in a position where everyone loses, and so these are difficult decisions that are made by courts as well. Brian, do you have thoughts on this?
Well, I don't fully understand the technology behind executing either of those or those various proposals that are floating out there, but I would say that it does seem like an attempt to try to keep people whole, at least by the people doing them. And I think that, it's trying to front run, essentially, potential lawsuits or regulatory action. I'm not, obviously a lot of people are paying attention to this, and it's, for the people who lost their DAO tokens, or if they're not lost, hacked, or whatever word you want to use, I expect there's going to be a lot of legal fallout here for the people involved.
Yeah, but I think, maybe we don't want to move here yet, but I think, the quote-unquote attacker, for lack of a better term.
We'll get to that in just one second, Pamela.
Yeah.
I'm going to interrupt you. Taylor, I also wanted to jump to you. You're a curator in this particular case. So in a certain way, you were involved in at least the governance model of the DAO for validation of proposal. You never got to exercise that role, and I want to make it very clear the curators were never involved in making any actions or actionable decisions. I'll give you some protection there.
Thank you.
But you were prepared to make some decisions about some proposals. How, as someone who's involved on that level in the DAO, what do you think of this proposal to do a seizure through a soft fork followed by a forfeiture through a hard fork?
Yeah, so it's interesting. There are probably about 4 or 5 different possible proposals about what to do in this kind of situation, depending on where on the party lines you fall, and it seems to be a range of holding lots of tokens to holding no Ethereum. And I think the issue is that we need to find some kind of common middle ground. And even though there will be no perfect kind of result, there are some possibilities. One of the things that gives us some time, at least, which is something important, because having these discussions is not instantaneous. It takes a long time to have thought experiments and explore it. So one of the things is the soft fork proposal that's been put out there, and that would basically be a change to the mining part of the software so that they can opt not to process certain kinds of code signatures, we'll say. So if there's a bit of code that looks like this, they can say, I refuse to process that and validate that as part of the chain.
Would you call that a blacklist?
Yeah, I mean, it is a blacklist of sorts. And I was, when I was thinking about this, it does offer a really interesting way to bridge the idea that contracts are self-executing, but still the humans and the social applications, there's a way to sidestep some sort of problems. People can choose to not do business with certain people, and this might be an effective manner of neutralizing some threats.
That's one of the really interesting points here. Now, I want to emphasize that this discussion is not predicated on finding the right answer or even supposing there is a right answer. I think probably the most obvious outcome of this is that things have gone badly wrong. Some people stand to lose a lot of money. This is a very serious question, which will have implications that may be very significant for some people, may have repercussions in terms of loss of funds. It may have repercussions in terms of lawsuits. But it also will have a bearing on what precedents are set and how the governance of the DAO and Ethereum continue from here on out, and how we see smart contracts in their application. But I want to go to the last question, the last topic you mentioned, Taylor, which is the idea that we use the social structure of Ethereum essentially by allowing the miners to vote if they want this solution, to undo the hard math of a smart contract when it's gone wrong, and to allow the soft judgment of participants through the consensus mechanism to create our own resolution. That sounds awfully like adjudication. It sounds like we're saying the smart contracts are the smart contracts, and if there are disputes, then we're going to use the consensus mechanism as the jurisdiction of enforcement of these smart contracts, and also as the jurisdiction of equitable restitution to those harmed. Pamela?
Yeah, I mean, that's the difficulty. The difficulty, and this has been brought up a number of times on Twitter, but the question is, where is the line here, and who is making these decisions? So, yes, if, for example, if the code is distributed and a miner says, yes, I'm not going to process, this transaction, or yes, I am going to adopt the fork code. Arguably, if someone has a loss, they could say to that miner and join all of the other miners who either adopted or failed to adopt that transaction in a lawsuit and say, you've cost me to say it easily, they could say, you've cost me X amount of dollars, you took my property, this is effectively a taking, and therefore, you have to make me whole. So again, we come back to that question of how are people made whole, and what is whole, and who wins. And I think we set a very dangerous precedent when we start blacklisting for a number of reasons, including but not limited to, I think it opens the entire network up to subpoena power. And I think that if we show that we have the power to blacklist certain smart contracts, I think that we would be foolish not to think that governments today will not attempt to use their power in order to make the network do that.
I've been very vocal against blacklists of any kind in cryptocurrencies in general, and we may be seeing the first example of this being applied at a governance level on a major cryptocurrency. Brian, what are your thoughts about the potential repercussions, the unintended consequences of trying to remedy this narrow case, but yet creating a precedent that has far-reaching consequences?
Well, I don't know. I think every case is unique. So I think what happens here, and I should give the caveat I heard Pamela say earlier, which is I'm not offering legal advice either, but in any capacity here. I think this is a unique case, and I think, yeah, maybe it will set precedent for how people handle things down the road in the sense that they will do things differently, but I don't know that a court or lawyers are necessarily going to look at what happened here and say, okay, that's how it has to be done in the future. I mean, I think there's a lot of still potential remedies out there, and people are considering them. And I'm curious to see what happens. Just as a spectator, I don't own DAO tokens. I don't have a personal interest in this. But I think that whatever happens here, people will look to. And I know people in the Bitcoin world are, there's some, sense of like, oh, well, look what happened to Ethereum, and look how Bitcoin's doing so much better. But that's sort of irrelevant for the DAO tokens and the DAO holders and how people are going to judge it there. I think Ethereum stands on its own and should be evaluated individually.
I absolutely agree on that, and certainly I think I've been one of the people to talk about distinct niches and ecosystems in which one system is better than another, and not really a head-to-head competition. I've never seen Ethereum as a rival to Bitcoin, and I certainly won't turn around now and see Bitcoin as a rival to Ethereum just because Ethereum has had this particular issue. So let's talk about some of the implications, but first I want to read you this letter, this open letter. Now, a quick caveat. This letter purports to have a digital signature on the bottom. The digital signature itself is malformed, which means that it's bullshit. We don't know who this person is. It's a paste bin. It's a completely anonymous account. In fact, given the fact that the recipient of this is a contract, and as far as I know, since a contract doesn't have a private key unless there's a function already in the contract to sign arbitrary messages, there's no way for a contract to authenticate against the address. Taylor, you might know a bit better here, but I'm assuming there's no way for the person who created the split proposal to prove that they are the person who created the split proposal, because there is no private key with which to sign a message, which would be the only valid proof. Taylor? No?
Yeah, I think that's right. I haven't looked into the message actually very much, and I was looking forward to hearing it read here. But if it is controlled by a contract, then indeed there's no private key to sign, so that would have to be built in. The only thing that could be done is a signal from outside that this person's private key sends to the contract, and
right.
if the contract could do something. But that would be pretty much the only way for them to authenticate.
And as far as I know, they haven't, and in fact they have completely disclaimed the possibility of identifying themselves, which is rather convenient. So as Vitalik said in the case of Craig Wright, there's an easy way to do this and a hard way to do this, and if you don't do it the easy way, it's because you can't, to paraphrase. So take this with a giant grain of salt, but the reason I'm going to read you this open letter is because of what my initial reaction was, and I had this discussion with Pamela Morgan about how this sounds like someone who is sophisticated in the term of law. They're using terms in a very specific way to establish a certain pattern of behavior and to set up something. This is not a naive letter. It is not someone who doesn't understand the jurisdictional or tort issues that come up in this particular case. So I'm going to just read this for you, and then we'll take some comments. To the DAO and the Ethereum community, I have carefully examined the code of the DAO and decided to participate after finding the feature where splitting is rewarded with additional ether. All emphasis is going to be mine, so just if I make funny voices and add exclamation points with my eyebrows, just please forgive me. I have made use of this feature and have rightfully claimed 3,641,694 ether and would like to thank the DAO for this reward. It is my understanding that the DAO code contains this feature to promote decentralization and encourage the creation of child DAOs. I'm disappointed by those who are characterizing the use of this intentional feature as theft. I am making use of this explicitly coded feature as per the smart contract terms, and my law firm has advised me that my action is fully compliant with United States criminal and tort law. For reference, please review the terms of the DAO. And here he quotes, or she quotes, or they quote, the terms that were included in the DAO Hub contract. Quote, the terms of the DAO creation are set forth in the smart contract code existing on the Ethereum blockchain at 0xBB9C, which is the address of the DAO. Nothing in this explanation of terms or in any other document or communication may modify or add any additional obligations or guarantees beyond those set forth in the DAO's code. Any and all explanatory terms or descriptions are merely offered for educational purposes and do not supersede or modify the express terms of the DAO code set forth on the blockchain. To the extent you believe there to be any conflict or discrepancy between the description offered here and the functionality of the DAO's code at 0xBB9BC, blah, 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 the DAO's code controls and sets forth all terms of the DAO creation. And the letter continues. A soft or hard fork would amount to seizure of my legitimate and rightful ether, claimed legally through the terms of a smart contract. Such fork would permanently and irrevocably ruin all confidence in not only Ethereum, but also in the field of smart contracts and blockchain technology. Many large Ethereum holders will dump their ether, and developers, researchers, and companies will leave Ethereum. Make no mistake, any fork, soft or hard, will further damage Ethereum and destroy its reputation and appeal. I reserve all rights to take any and all legal action against any accomplices of a legitimate theft, freezing, or seizure of my legitimate ether, and I'm actively working with my law firm. Those accomplices will be receiving cease and desist notices in the mail shortly. I hope this event becomes a valuable learning experience for the Ethereum community, and wish you all the best of luck. Yours truly, the attacker. I read that, and it strikes me as something that has a fair degree of sophistication and legal understanding, has set up certain parameters in such a way as to strengthen a particular case, and is also exhibiting a very large amount of understanding of smart contracts, but also a very large amount of being a smart ass. Let's
agree completely.
Now, we have no idea if this is the attacker, but even if it isn't, that brings up a really good point. If the terms of the contract are controlling, and this was done through execution of the smart contract according to the consensus rules of Ethereum, in full accordance to the code by a DAO token holder, why is this a theft? How is this a theft? How is this not simply using the contract as explicitly defined? Let's try Brian. Okay, Pamela.
No, go ahead, Brian. Feel free.
Well, I haven't read the terms of the contract that closely, but
the terms of the contract are the code, right?
Yeah.
Well, I can't read codes, so there you go. I would say that this person, obviously, it sounds like a troll to me, but maybe it's the real person. Let's assume it is for the purpose of this. They're setting up a defense. So they're like, hey, I'm just following the rules here, and I just happen to be the big beneficiary. Too bad, so sad for the rest of you. I mean, you can raise that defense, and maybe that will work. I haven't delved into the details enough, but I'm sure other people, and I know other people, feel radically differently than that they've been cheated and swindled. So, you know, that's often what you have civil litigation over, is one person feels like they got taken advantage of and files a lawsuit. And, you know, sometimes legal authorities or regulatory authorities get involved because they have a third view, or they share the plaintiff's view.
Well, let's look at one sentence in specific.
I'll just say real quick. I can't imagine a reputable law firm gave a definitive opinion like the one expressed in that letter. I'm not saying this person didn't consult with a law firm, but it's very hard to get a law firm to say definitively, yes, you can do that, you know, straight up. There's a lot of caveats lawyers give, just like I'm giving on this talk.
Well,
lawyers
I
don't
would
usually
disagree
give definitive
with you
opinions.
I would disagree with you there, Brian, because I've read John Yu providing very specific legal advice that purported to legalize international war crimes to President George W. Bush. So you can get a lawyer to say pretty much anything under the right circumstances.
Well, I did have the caveat reputable in front of that.
Reputable.
So.
Yeah. Well, John Yu is still walking free. So let's,
and I don't know. Yeah.
Let's go to the first sentence, and I'm going to switch to you, Pamela, because I think this one really shows a clear understanding of contract law. I have carefully examined the code of the DAO and decided to participate after finding the feature where splitting is rewarded with additional ether.
Yeah, so let's talk about this. Okay, so that seems like kind of a strange sentence, right? Like, it's very calculated. And let me tell you why I think that is. For contract law, you have to have an offer, acceptance, and consideration. And so assuming that we have a contract here, this sentence speaks directly to a contract defense called mistake. So I think many DAO token holders, and likely the people who wrote the code, did not realize that this was part of the contract. This was an unintended consequence, right? They didn't think that this irregularity was included in the contract. Now, as far as the defense of mistake goes, and let's talk about this. If you are able to assert the defense of mistake, then there's no contract. And if there's no contract, then there's an equitable remedy. Then you can return the parties to their warm and fuzzy state, right? So this person, whoever drafted this, my guess is they were trying to say that this was not a mutual mistake, meaning they didn't, neither party knew. He or she, excuse me, is specifically saying, I knew that this was part of the code, and it induced me to invest in the DAO. That is a very calculated sentence. And, you know, arguably, this is trying to say that because one party knew and the other party didn't know, it makes the argument much more difficult. If both parties make a mistake on a material issue in a contract, then there's a good argument that that contract can be unenforceable. It seems to me, and I'm sure that there are other legal issues surrounding inducement to invest in the DAO, but it seems to me that this sentence speaks directly to the lack of mutual mistake and moving it into a unilateral mistake, a single person mistake. You know, I think that we need to go back quickly and talk about this concept of all of the terms and conditions being, as the coder said, included in code. And there's something in the enforcement of contracts. There's a concept called constructive conditions. And constructive simply means the judge makes it up. They put it in there because otherwise there would be an unjust outcome. So we have something called constructive notice, where you should know, where you do know or should have known something. In this case, a judge could put into the contract something called constructive conditions, even if both parties say, no, 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 what's in this paper, what's in this code is the only thing that we are going, these are the only terms. A judge does have the latitude in a common law country, if they want to apply an equitable remedy, can say, even though the parties said that these are the only conditions that apply, no, 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 that's unfair, that's unjust. We're going to read into the contract, that's the language they use, we're going to read into the contract these additional constructive conditions in order to have a just result, so that one party doesn't get what's called unjust enrichment.
But in this particular case, one of the many outstanding issues is the issue of jurisdiction, which is that by virtue of the floating above jurisdiction fiction of smart contracts that was created here, presumably the attacker, if they actually choose to sue, which is a whole other can of worms and really unlikely for many reasons, they could simply pick any jurisdiction in which a DAO token holder who is one of their general partners resides, or one of the miners, or any one of the developers who implements any one of the bits of code that do the soft fork, and basically jurisdictions shop and say, you know what, I didn't like the fact that you called me a thief, and so I'm going to sue you for slander in the UK. I didn't like the fact that you took my money. I'm going to sue you for seizure in Panama, or wherever, right, and pick the jurisdiction that is best for each one of the cases. But, of course, that presumes they'd have to identify themselves.
Yes.
All right, I'm going to grab another beer and let you talk amongst yourselves for a while. Don't forget, for our audience questions, hashtag LTBDAO on Twitter, or on the DAO Slack, just mention my name, AANTONOP, and we'll take questions from the audience in the next round.
Yeah, I mean, I think this is the issue. Brian, do you want to weigh in on the jurisdiction questions at all? Because I spoke about this earlier.
And what did you say, just so I don't...
Oh, no, but the thing is, you know, these things can all come out in different ways. Legal opinions differ, friends.
I think people will try to choose the jurisdiction most favorable to them if they're going to bring a lawsuit, and whoever side of this they're on. I mean, whether it's, civil plaintiffs or this person who's controlling these DAO tokens through the DAO child, whatever the setup is. I think those parties will choose whatever they view as the most favorable or most convenient, most cost-effective jurisdiction if they want to litigate this. So I don't think, and maybe they'll succeed and maybe not, and there'll be lots of arguments over that. But I can't imagine a U.S. court, a federal court, even a state court, frankly, with a victim in it, quote victim, however you want to phrase it, wouldn't feel comfortable taking jurisdiction over this case because there's someone living in their jurisdiction who lost the DAO token to this other person, or however you want to phrase it. Again, that courts are pretty friendly, and I'm in California, especially very friendly to plaintiffs. So,
well, and especially when they're voters, and in the U.S. in many jurisdictions.
Federally, there's the federal jurisdiction and the federal courts have a very long reach.
Absolutely.
So to me, it's, now can they actually, is this person known? Are they ever going to identify themselves?
Well, this is the issue, right? If you want a local court to help you enforce your rights, then you have to come forward, because the court is not going to, you can't come forward with a pseudonym, I don't think. The other question, of course, is then enforceability. And once you get an action, how do you actually enforce the judgment?
Well, there's mechanisms for that. No, there's mechanisms for that. I mean, in state courts and federal courts to enforce judgments. So that I don't think would be a problem.
Well, yes, but I mean, if the judgment is against the DAO,
I don't think anyone's going to bother to get a judgment against the DAO. You need to be able to identify. You want to be able to identify a person or where funds are if you're bringing a lawsuit. And if you can't identify a person or where the funds would be, I think a lot of lawyers would tell their client, this may not be the best lawsuit to bring, because at the end of the day, you're not going to have anything to show for it.
Yeah, I also think this letter is interesting, where this person says that he or she uses the word accomplices, and anyone who are the accomplices who work together to deprive me of my property will receive cease and desist. I think that's a very interesting choice of language.
I don't think that's going to happen, because as soon as someone gets a cease and desist, they're probably going to post it on Reddit.
Oh, right? Yeah, for sure.
And everyone's going to know what this law firm is and who this person is. I mean, maybe that will happen. I mean, we'll find out pretty quickly.
I mean, is there a case to be made against miners who refuse to process transactions with specific code strings in them? I mean, is there really a case to be made that they did not validate and do their job? Can they refuse to do that? And does it seem like he really has a case to bring against them for refusing to do business with them?
Well, I think the U.S. legal system is very plaintiff friendly, and it's very easy to find causes of action to bring against people that have, at least on the face of it, will survive a challenge. Now, at the end of the day, if they had to go to trial, would they win? Maybe not. But I think that a sophisticated, creative lawyer here can come up with some causes of action that will withstand at least initial scrutiny against various parties, whether for the person who has these tokens or the people who tokens this person has. So I don't, at least in the U.S., I don't know. I can't speak to other jurisdictions. But I don't see it as a problem. It's usually not a problem to bring a lawsuit. It may be a problem to win. It may be a problem if it really has merit. But to bring a lawsuit is fairly easy in the United States.
Well, and let me jump in and say, if we have an arbitration clause, and I don't mean to harp on this, but I really do think it's this important. If we had an arbitration clause in the terms and conditions, if someone did file a lawsuit in their local court, you as a respondent to that would say, no. We don't have to do this here. Judge, you have to send this to arbitration. And if it's done properly and if it's done legally, that local judge cannot hear the case. Now,
yeah, that's generally true. You're right. And
yeah,
I thought
there are always exceptions.
I thought there wasn't an arbitration clause in the DAO.
No, there is not. I'm saying we need to. This is a best practice. Friends that are listening, please do this. Just add terms and conditions and include arbitration. It's so easy. It's free. There's a clause builder on their website. It doesn't mean that it's going to save you from everything, but we as an industry need to be better at this, because if we don't, we're going to end up having more and more of these discussions. And it's not really fun for the DAO token holders, You know, it's legally interesting to have these discussions, but at the end of the day, there are people who have lost millions, and they don't really want to be dealing with this. So I think to the extent that we can mitigate risk by making these sorts of choices, arbitration, venue clauses, I think it's going to be better all around. And with arbitration, we can select arbitrators that have technical knowledge in our space. We don't have to just get whatever potluck judge we get. We can actually say, these are the qualifications for arbitrators. They must have coding experience in Solidity, for example. And you can make that.
Probably going to be like one judge if I.
Right. Well, I mean, right now, yeah. I mean, we're new.
Judge Pamela.
Yeah. Well, you know, no, there's a number of other lawyers that can do this, but you know, the issue is that we can then choose who we want to decide and what laws they use to decide. And I think that if that had happened in this case, we would have at least a bit more certainty.
Well, arguably in this particular case, what has happened in the absence of setting a choice of law or having any arbitration clause and requiring the DAO contract code to be the one only authoritative contract that exists, is that we're having arbitration by Ethereum chain consensus mechanism. And this has a number of other implications. Let me
jump in for just 1 second there. And if you actually do arbitration, arbitrators have contracts that that I don't want to say reduce. I want to say prevent them from being held personally liable. The issue is, in this case, yes, we're getting arbitration by developers or miners. The problem is they don't have the protection, the legal protection for making those decisions, right? If I'm an arbitrator in a case, I'm not going to agree to be your arbitrator unless I say, well, you can't sue me personally for a decision that you don't agree with, because inevitably someone is not going to be happy. That's the nature of the beast. That is part of, part of dispute. And so if we have this sort of adjudication by coders and by miners and by whomever else, they don't get that protection. And that's one of the things that I think is most dangerous about it.
Well, this sets up some really interesting incentives because on the one hand, you have some 25,000 DAO token holders who are all jointly and severally unhappy and are prone to be litigious in the case of this money really getting drained and lost by the DAO token holders. And on the other hand, you have a mysterious attacker or attackers who have really no recourse other than revealing their identity, which would point to the bias or incentives heavily skewed towards protecting or reversing this in such a way as to make whole the 25,000 DAO token holders than considering, the possibility of the attacker suing. But there are a couple of wrinkles that I want to get to next, and then we'll go to some questions. Wrinkle number one, the proposed soft fork as created at the moment, and this is how it has been implemented in Parity, how it was suggested by Vitalik and Christoph Jens, and including the proposal for the hard fork, is to prevent any transactions that withdraw from any code segment that has the fingerprint, a specific fingerprint that is the DAO 1.0 code. Now what this means is that it prevents any withdrawals from either the parent DAO, the DAO 1.0, or any of the children DAOs, because children DAOs automatically create a clone of the 1.0 DAO code and would prevent any withdrawals. And then the proposal is for the hard fork to implement a scheme by which all the funds that are in any code segment with that hash are transferred to a refund DAO from which the DAO token holders can claim a refund. And here's the one big wrinkle that I've tried to verify earlier, and we'll get to Taylor and find out if this is correct from a technical perspective. This code hash includes any bytecode that is implemented DAO 1.0. I implemented DAO 1.0. I'm running a copy of DAO 1.0 on mainnet in order to test the software on mainnet. And I believe it has a tiny amount of Ether in there. Others may have chosen to run this exact same DAO code. Now, while there is a vulnerability in the DAO code, if you know all the DAO token holders and know that none of them can or will exploit this and get away with it, then it's perfectly fine. Yet, as soon as the soft fork passes, my DAO codes that has nothing to do with this has been seized or frozen. And if the hard fork passes, my DAO code and its Ether gets asset forfeited directly into a refund DAO and given to the DAO token holders who have nothing to do with me. This seems to me to be a very rushed decision that has some really nasty implications. Taylor, did I get the mechanics of this right? Are they really doing it based on the fingerprint of the bytecode and will affect any instance of DAO 1.0 code that has not changed the code?
Yeah, so you did get that right. There are two parts to it. It's important to note. One of the proposals is called the soft fork, and this is basically refusing to process code signatures that look like a specific thing. And right now, this is kind of a broad approach. But I've already discussed with some of the developers some of the other possibilities, and there could be a more targeted approach. I think at first, one of the big priorities is stopping the quote-unquote attack vector. And to put a freeze there and have time to make a qualified decision is really good. So if we can get a large kind of freeze on this problematic behavior and then target the specific addresses, perhaps in the specific blocks, this might be akin to a blacklist of sorts, but it gives the most balanced proposal, since right now the attacker doesn't actually have access to their funds. They're locked in the child DAO for a bit longer.
Nevertheless, this would also block my instance of DAO 1.0 code that I'm running.
Yeah, in the first proposal that's been made, that's my understanding, is it would affect all instances of it, not specific ones.
Well, here's the interesting thing. I can't do anything about that, because if I started a split right now in order to get around this impending soft fork that's coming, it would take 27 days from the moment I started a split. So I can't unwind my own DAO in order to get any kind of recourse from my perfectly well-functioning DAO with my own property in it, which means that effectively the miners, through the introduction of this soft fork, will unilaterally and without recourse confiscate my money. Do you see a problem with that?
Well, I don't see it as outright confiscation. At the moment, you can't send a transaction that will do that particular withdrawal function.
Right, so they will seize my money. They won't confiscate it yet, but they will seize. Freezing assets is a seizure, at least legally speaking.
I couldn't comment on the legal definition of it. I'll take your word for it.
Yeah, but did you have a problem with that? I mean, it seems to me that this soft fork is a bit ill-considered as to its side effects. It assumes that the only DAO that's running DAO 1.0 code is the DAO, but that's not true.
Yeah, there's no good decisions here. I mean, there's a lot of possibilities, and no one comes out a perfect winner in the end. I think that we have to accept that there will be some fits and starts to getting past this. The worst situation, I think, is to do nothing and just let the DAO drain completely. Maybe some people might like that from a code idealist purity perspective, but I think that's the worst for all parties involved at a human level.
Without a doubt, and that will also create 25,000 highly litigious, angry people who will turn around and take this to every jurisdiction you can imagine. Because of 25,000 people, I bet you're going to find a couple who are going to sue you in every jurisdiction imaginable.
Taylor, can I just jump in one quick second? Taylor, have you guys behind the scenes talked about this issue at all? Like, is there a way to identify who the DAO token holders are versus other people who may be running this instance, and is there a way to kind of refund the money? And also, you mentioned that it's a two-stage process, so I'm interested to know if, from a technological standpoint, this is something that can be done.
I'm not perfectly sure if it can be done. I think it's theoretically possible to get almost all the way there, if not all the way. One of the things that I have seen someone do is import the chain into Google for some sort of data analysis, and we're running some sort of spreadsheets on that. And one of the things that I personally wanted to know is, after Andreas had tweeted about it, was what other instances of the DAO 1.0 code are out there, and how much funds are we talking? If they're just playthings and there's relatively low amounts, below thousands, I think that it's low risk in terms of affecting other people. But if there are larger funds out there, certainly that's gonna piss off a lot more people. So
well, and maybe there's a way, but maybe there's also a way. I mean, it's hard for us to say like what matters to people, right? Like maybe someone's 1 ETH is like everything to them, you know. So it's hard to say.
I mean, the precedent this sets is astonishing. We're talking about people who have very idealistically participated in a scheme that is about changing the fundamentals of you know, the justice system and how we organize society, and here we are cavalierly talking about, and I don't mean you, Taylor, I mean the whole space is really looking at a least worst solution where one of the options is casually confiscate, as long as it's just a small amount, from people who had nothing to do with this. I mean, just from so I can imagine there's a lot of people who are ideologically opposed, and we saw from Slockit, and this quite shocked me, that they accused people who are objecting to the soft fork as siding with the thief. And I thought that was a rather cavalier attitude to take when what we're talking about here is property confiscation. And when you're talking about property confiscation, whether it's 1/10 of an ETH or an ETH or $55 million, we have to take those things very, very seriously. And I would argue that someone who has 1/10 of an ETH taken from them could quite easily sue someone for this.
Yeah, absolutely. I mean, if they were going to pursue that route, the value of 1/10 of an ETH is certainly less for them to sue for. Perhaps there are other damages civilly. I'm not really sure here because I'm not a lawyer. But I think it is important, as we talked before, to learn from earlier precedents. And there have been cases where other blockchains, and talking about Bitcoin here, have had to deal with these kinds of issues. And there have been reversions and hard forks. So we shouldn't look at those necessarily as a black spot, but what was learned from them and what were the outcomes of them and who was affected by them can help inform us of what kind of decisions can be made now.
Well, in fact, I want to clarify this point because it's a claim that's been made a number of times. There have been two forks that have related to bugs in Bitcoin. The most recent one was in April of 2013. This involved a fork because of an incompatibility between version 7 and version 8, or sorry, 0.7 and 0.8 of the software. No money was changed hands, no transactions were canceled, everything was replayed in exactly the same order, and it involved simply changing the software version. Now, certainly miners who found themselves on the wrong side of that chain lost the reward that they would have gained, but no transactions other than the Coinbase transactions, the reward transactions, were affected. If you go back to 2010, we had an incident where due to a bug in the software, a Coinbase transaction created some 92 million Bitcoin. I can't remember the exact amount, but essentially someone mined an exorbitant amount of Bitcoin, and this was validated by the network. And then the code was changed to correct the consensus rules, and that block was invalidated. But again, we're talking about a Coinbase transaction that was mined. Never in the history of Bitcoin has a hard fork or any kind of fork resulted in the reversal of specific transactions in such a way. This is unprecedented.
Well, in both of those situations, you had somebody who could have benefited had the fork not gone through. If the status quo maintained, there could have been a beneficiary. And I think it's interesting we kind of had
yes, but that beneficiary was a miner who was materially participating in the validation of consensus rules. I think that's a very different situation than someone who's simply running a contract. And again, I'm not saying that bad things haven't happened in Bitcoin. And I'm not saying that this is the wrong choice for Ethereum. I'm simply saying we really are facing an unprecedented situation. This could happen in Bitcoin too. You could have, for example, when Mt. Gox happened, at some point we could have had people arguing for a hard fork to reverse transactions that left the cold wallet of Mt. Gox. We traced those through, and in the early days you could have done that. Nobody did that in Bitcoin for very specific reasons. In Ethereum now we're talking about the very real possibility of doing that.
Yep, indeed. It's going to be a really interesting time as we get through this. There's a lot of options. None of them are perfect. We're just going to rely on talking with people and discussing. As I tweeted before, doing nothing is also an option. We may end up going that route. I think it would be probably the worst outcome for the ecosystem as a whole, including blockchains, because we do have to get past some of these governance issues, and doing nothing would show that we still haven't moved past solving the governance problem.
Right. Doing nothing essentially means destroying at least $54 million worth of value. But arguably, those would be returned to the ecosystem in the form of sales for the person who profits. All right, I think we've gone around this topic a few different ways, and we can all agree there are no good solutions, but certainly there are some least worst solutions, perhaps that need to be tweaked a bit to make sure they don't unnecessarily sweep innocent DAO instances in their effect. But certainly, it seems like the solution that affects only the attacker and not the 25,000 DAO token holders might be the best from the perspective of everybody involved. All right, so let's talk about the next topic, which is great. Let's say that's the solution. Can we actually pull it off? Well, just today, in an interview that happened, I'm just going to pull this up. This was an exclusive interview with Crypto Coins News. Andrew Quenson said that they received contact from, again, the alleged attacker, no way to verify it, and conducted an interview. Part of this was based on the appearance of the alleged attacker in the hashtag general channel on the DAO Slack. And the attacker gave out 6.37 Bitcoin as a demonstration that money speaks and people will take money even if it's paid by an attacker. And then suggested that the way out of this would be they would give 1 million Ether as a bounty to miners for simply refusing to implement the fork. And this gives miners complete plausible deniability. They don't have to do anything. They just have to not upgrade to the latest parity or geth code, ignore the soft fork, and as a result, supposedly the attacker is saying they will generate 1 million Ether reward that they will distribute to the miners who mine the next few blocks after the supposed soft fork point as a bounty to not do the soft fork. Now, if you're a miner, put yourself in this position. You're now like, okay, Saint Vitalik is saying I should do this, and certainly, you know, we all have enormous respect for the inventor of Ethereum, and his opinion carries tremendous authority. But also, a lot of the other developers, a lot of the participants in this, everyone from Slockit for obvious reasons, and a lot of other people saying this is the way we should do it. 25,000 DAO token holders is saying, give us back our money, and you're a miner, and you're like, okay, I'll weigh this on one side. There's 1 million Ether hanging on the other side. Suddenly this becomes a really tough choice. And part of being a miner is making game theoretical choices based entirely on self-interest. It sounds like the attacker just threw a giant wrench in the work and used the consensus system to gain the upper hand here. I'm really beginning to wonder whether the fix is really in. Taylor?
That's an interesting one. Yeah, it does come down to the miners in the end, and that's kind of what I've been saying. It is the community's choice about what to do. What is a million Ether worth today after this action? I have no idea whether the price is going to go up or down based on the reflection of that. Sorry?
$12 million right now. Let's see where it goes.
Well, right now, but can you clear that through an exchange fast enough, and what is going to be the market sentiment while you're doing that? Versus what is the value of the blockchain ecosystem if we take off, and not billions, but we're talking about trillions of dollars invested into a world that does believe in this technology and the transformative power, a single contract recursion bug notwithstanding. I mean, let's remember, EVM and Solidity itself are working as intended. This was an unintended side effect of a particular implementation, not a reflection on Ethereum as a possible platform.
Right, and the bottom line is that all of this assumes that the attacker is telling the truth. I mean, they could just as easily lie. Miners don't implement this soft fork. They don't get the reward. That wouldn't last very long. That would only encourage them to implement the soft fork. You've got a really interesting game theoretical model here with different strategies evolving. What I find really ironic here, but also heartening, is the fact that this simultaneously demonstrates some of the flaws in the ecosystem, but at the same time, it clearly demonstrates the fact that the governance model is decentralized. Because if it was easy to solve, Vitalik could just say, you know, let it be so. And he can't. He can propose code, and that code may or may not get implemented, and the attacker can come back and say, hey, I'm going to give you a bounty and don't do this. This is still a decentralized system. So we're seeing at the moment in the market a reaction that says this has been fixed. The price dropped and then bounced back and then stabilized somehow, and it stabilized near the all-time high just before a couple of days before this happened. And people seem to think this has been fixed. I'm extremely skeptical as to, in fact, whether there will be a refund of the DAO. I think this is still up in the air.
Absolutely.
Which, at the same time, has the ironic aspect of demonstrating the fact that Ethereum is decentralized. Because otherwise, this would have been fixed in a much more assertive way. And the consensus mechanism of miners with proof of work is very effective. Now, we don't know if we're going to have lawsuits come out of this, but certainly we're going to watch this governance model get tested to its absolute limit, both in terms of good intentions and whether they might play out, as well as the potential for self-interest to get in the way, and the repercussions in the long term of this ecosystem.
Let me ask a quick question. You know, if this bounty were actually paid, if there were transactions that, you know, transferred a million ETH to miners who did nothing, would then the response be to reverse those transactions? And how does this play out? What ultimate control? You know, where is? I'm sorry, I'm a lawyer. We do the slippery slope. We can't help it.
It gets better than that. I got some comments on the DAO Slack channel. Thank you, everyone, for dropping in your little comments. But here's another one that someone came up. You know, the attacker could be lying, but the attacker could also underwrite their promise with an Ethereum smart contract that guarantees execution of their bribe. What a twist, right? I mean, they will guarantee a bribe through the execution of a smart contract that the miners themselves control, in a way, through the consensus mechanism. So this bribe could actually become an enforceable Solidity promise. Solidity. It's a solid promise.
Let's just hope he leaves out the recursion vulnerability from that contract.
Right. I mean, the levels of irony here are pretty strong. Let's see if we can take some quick questions from the audience. I'm going to open it up for questions next.
I have a question.
Yes, please. And it's the YouTube video is delayed by a few minutes, So I'm going to ask people to send me some questions now, and I'm going to go back and see if I can find some. And let's delay things in the meantime and continue this conversation. Pamela.
Great. So I have a question, and in full disclosure, this is something that you and I had talked about when we were chatting about having this hangout. So I am not an expert in proof of stake. I'm just going to say that right now. But if nothing were done, if this person continued to hold this amount of ETH, in what way, if any, would that affect a move to proof of stake?
Yeah, well, to clarify, we're talking about 5% of all Ether in existence. This person has a 5% stake right now. Or the contract does, assuming they can get it out.
Right. In other words, if the question really is, like, if it's actually possible that we're not, that we as an ecosystem are not going to reverse this, then doesn't that have an unintended consequence if there's a move to proof of stake, where this person who arguably did not act in the best interest of the community now has a substantial role?
If you assume that that letter is real, this person is someone who actually is hostile towards Ethereum and wants to see it fail. In the interview, they called it a shitcoin, and I don't think that. I'm not saying that. They said that. So you're talking about someone who is actively hostile, potentially, to the concept of Ethereum and trying to prove something, holding a 5% stake. I mean, Casper is a ghost that's already dead.
Yeah, it would not be a good way to start off proof of stake, having an untrusted entity holding a large percentage of supply when supply held is what dictates consensus. I think that's probably the disaster scenario, and something that a lot of people are very concerned about for sure. What we're going to do to kind of get out of this pickle, I don't know, but it's going to be a tough road there, I think.
Taylor, is there any thought about limiting, like, how much a DAO, I'll use the DAO in a general sense, can raise? I mean, it seemed like obviously part of the problem here is just the incredible value, the incredible amount of money at stake.
Yeah, I mean, the only way to do it is have the DAO reject transfers after a certain limit's been reached. I believe that is possible with Solidity, to throw the transaction and have the refund sent back, basically. But that's, again, up to the authors of that code to implement that.
So there is no limit. Someone
yeah, in the
codes
case
it,
of
they
the
can do
DAO,
it.
there's no, yep, absolutely.
But we now know there's a best practice, right? I mean, we've now learned the hard way that maybe, you know, I think didn't Vitalik say in his paste bin we should not be using smart contracts that are greater than 10 million right now? Wasn't that just a recommendation? We should try to limit.
Yeah, and I think that sets a reasonable level for a security bounty that you could lose through a hack and still not affect the ecosystem. The problem is the DAO became huge at more than 150 million before that limit was set, and as a result, now its failure did affect the ecosystem. All right, let's go to questions from the audience. If you have questions, hashtag LTB for Let's Talk Bitcoin, DAO for Decentralized Autonomous Organization, hashtag LTBDAO on Twitter, or on the Slack channel. I'll get to as many questions as we have. First question from the audience: what kind of beer are you drinking? And this is the Apex Predator, and which I believe is a Wisconsin beer. I'm going to say the wrong thing, and then people... No, it's a Chicago beer, which I got from my local artisanal small batch gluten-free organic vegan brewery, or whatever the hell that is. But it's delicious, so I would recommend it. Okay.
Not vodka.
Okay. Do you think, question number 2, do you think this invalidates Solidity, or invalidates Ethereum, or invalidates the concept of the DAO in any way? I'll go last. What do you think?
I would say absolutely not. Ethereum so far is the best attempt at smart contract platform, DAO platform, whatever it is that we can see that this thing could be. There doesn't seem to be another competitor in terms of overall popularity and functionality at this moment. That doesn't mean that there won't be some sort of successor technology, but for right now, this is the best tool we have for this job. And I think for that reason, people will still look to Ethereum for building these kinds of applications and platforms.
Well, and I think, you know, we have to acknowledge that this is a brand new world. This is something completely new. You know, I know that I don't buy new gadgets, the very first one, because I know it's going to have glitches. I know there's going to be something wrong with it. And so we are playing in the, you know, how old is this code? Not even 2 years? You know,
the Lightning Network's only been 10 months.
Yeah, okay, so 10 months. You know, so the expectation that we're going to do this perfectly, I think, is ridiculous. And I think that, you know, we know that there are going to be mistakes made. We, you know, being the ecosystem, being Bitcoin, being, you know, the Ethereum system, or any cryptocurrency sort of systems, you know, yeah, there are going to be mistakes made. And unfortunately, you know, usually we try to do it on a small scale. This time it became a really big scale. But yeah, I don't think this means the end for any of these things. I certainly hope not.
Sorry to interrupt.
I
think it's going to color public perception broadly. I think you'll see stories in the Wall Street Journal, the New York Times. You know, the extent people have heard of Ethereum, they will now. It is like the Mt. Gox in that sense. You know,
my dad texted me this morning about the Wall Street Journal article, and he said, "You were right about the DAO." I was like, "Oh, that's like the cutest thing ever." And then I talked to him, and I was like, "But wait till you hear what happened in the last 24 hours. Holy moly!" So yeah, I totally agree with you, Brian.
So I think, you know, that's going to I don't know, hold Ethereum back, but it's definitely going to weigh on Ethereum for a while. And particularly, I think, depending on how this shakes out. I mean, we're still, whatever, 24, 48 hours, 72 hours into this incident. I mean, there's a lot that could happen in the next couple weeks, months, that will influence things. I think people now will, you know, look at Ethereum a little differently, for better or worse, for at least the next couple months, to see how this gets resolved, and then people will come to some sort of consensus, no pun intended, about how they feel about it.
I think the governance and resolution of this are going to be critical. The world is watching. There's going to be a lot of scrutiny, and many participants in Ethereum have an opportunity to prove that they will do the right thing in the right circumstances in a way that creates the right precedents. I'm going to jump in and say I'm bullish on Ethereum. You know, quite honestly, fuck the reputation. They said everything bad about Bitcoin, and we're still here. This is a real-life experiment for 100.
How many of those Apex have you had now?
I've had 2, but
it's like
that's
12%
not why.
alcohol.
Yeah, that's not why I'm bullish. You know, the thing is, they've said everything bad about Bitcoin, and it continues to prove day in and day out that it's survivable. They're going to say bad things about Ethereum. Who else is doing real-life production utilization of smart contracts right now? All right, nobody. R3 is going to spend $220 million building shit chains as proof of concept for marketing reasons. If for $150 million we set up the world's most awesome security bounty to prove some really critical smart contracts technology, learn some hard lessons, get kicked in the you get kicked in the butt by this. It hurts for a bit, but I bet you reentrant code is going to be written a hell of a lot more carefully from now on. At the same time, generating this enormous momentum for funding projects through DAOs, which will come back again and again and can become successful experiments. You know, this is the essence of capitalism. You do experiments, these experiments fail. They have a very high failure rate. caveat emptor, you signed up for the DAO. If you didn't know this was risky, if you thought you were going to get a 6,000% return in 3 months, you're an idiot. And part of that was don't put in more money than is worth. Now, I have all the sympathy in the world for people who are going to potentially lose a lot of money, and I hope that we find the right solution. But the experiment itself is awesome. I compared the DAO to particle physics. The most interesting scientific results are in the debris of the fiery explosion that happens, right? Well, guess what? We will now have years to study the fiery debris, the debris from the fiery explosion of the DAO. And it will teach us some extremely valuable lessons about governance of the DAO, about governance of Ethereum, about whether smart contracts are binding, about how you handle jurisdiction. Hopefully, it's not going to teach us too much about lawsuits flying around, that affect miners and other developers. But I am bullish about this experiment. Absolutely not. This does not damage Ethereum in the long run. This was worth doing. It is the basis on which we proceed. We have to proceed experimentally and experientially, and that means putting skin in the game, trying it out, failing, getting up, and doing it again. I'm looking forward to DAO V2. Caveat emptor, be warned, it's going to be bumpy. You could lose your money, and let's learn how to build a really, really robust smart contract system, and the best way to learn is by making mistakes. That's my answer. I'm optimistic.
Great answer.
All right, let's take some more questions. The DAO Slack really enjoyed that answer. All right, but what can we learn from this? Do you think people will resubmit proposals to a new DAO? Do you think we can build new DAOs with the same level or comparable levels of fundraising? The DAO was the most successful crowdfunding project, or as I like to call it, mosh funding project, because this was definitely a bit of a mob. It was the most successful mosh funding project in history. Do you think we can repeat that?
Long term in the future, absolutely. I think in the short term, we'll probably see smaller attempts, probably with reduced complexity. That seems to be the main issue here, is the amount of complexity. So they'll probably be much smaller in the near future, but in the long term, if blockchains are a thing and they do continue to grow, we'll see much, much larger values put into these kinds of systems because they are ultimately useful.
Yeah, I just want to jump in quickly and say, if people aren't familiar with Common Accord, commonaccord.org is a project that aims to combine code and human-readable legal language. So the idea is that you can put in a line of code into your smart contract, and it will provide this legal template or legal contract for you. And when I say legal, I mean able to be read by a judge or an arbitrator. And I think that's a really, really interesting project, and I think it's quite timely, especially for people who aren't really interested in writing big, long legal contracts, which is most of us, myself included. And I think that that's a really interesting project that's providing some tools and some ways for us to move forward without encumbering us with all of the traditional legal issues, but also allow us to move aside and outside of it. So for those people who don't want to write big, long contracts, you can include snippets of code that do reference quote-unquote enforceable legal language.
So here's the another interesting question from the audience. I think this is it sounds flippant, but it's not. It's a deep question, and we need to answer it. What is the difference between a government or bank who decides when to override the free market and a blockchain that does the same?
Yep. No answers on that one. The only thing I will say is that typically in contracts you have a duty to mitigate damages, and this means that you have a duty, if you can, to prevent additional damage. So I would say that it's important that the ecosystem is looking at every possible alternative to this, and that's about all I have to say.
Well, I think that people will ultimately pick blockchains, so to speak, based on, do they want it where someone can intercede, or do they want it where it's more autonomously run? I mean, I think Bitcoin seems to be more hands-off, right? And if Ethereum gets more hands-on, that's going to change the perception of it for people who are investing and building in it. So I think, and maybe there'll be a third blockchain or a third shared ledger, whatever you want to call it, that rises because it offers a different variable. So I think it's just people will pick what they want and what they feel comfortable with for whatever they're trying to do, and all these things can be innovative in their own way.
I could be way off here, but I don't think that the Ethereum community wants to be known as the hands-on blockchain.
I'm not saying they do, but I'm just saying that could be a perception if some of these proposals go forward.
I wouldn't worry about that. I think decentralization is a spectrum, and you can have, Bitcoin is not entirely decentralized, Ethereum is not entirely decentralized, but when it comes to the hands-on moniker, I can guarantee you that the R3 banking consortiums have the hands-on your short and curlies absolutely stitched up and guaranteed for them. There's not going to be any comparison about who is really, really centralized. Thankfully, we have the banks demonstrating exactly what the centralized locked-up permissioned option is, and we can all steer clear of that. But you're right. I mean, this is going to be a matter of range of decentralization, and the question is, at this level of maturity of things like Solidity code, can we achieve the same level of hands-off, let the code execute as it does decentralization, or do you need kind of this, either consider it the benevolent dictator a la Linus Torvalds, Vitalik Buterin, magic touch, or appeal to majority resolution through consensus mining, which is a perfectly valid answer, again, as to how you resolve these conflicts, what Taylor called the social side of the blockchain.
Yeah, I think that's part of the interest in the space, to me, is it's so innovative, and there's all these different ways you can approach the same problem, or different problems even.
Well, here's another thing that came out of this, which I think is rather interesting. Vitalik just tweeted earlier today, I'd like to see at least 10% of the network running parity in 1 week. This is a good opportunity to get client decentralization as any. In many ways,
could you explain what that is?
Okay, parity is the alternative client written by the ETH Core group, which is headed by Gav Wood. And what it provides is an alternative implementation from, let's call it the reference client, which is Geth, the Go version of Ethereum, that is run by the vast majority of the network. This is really interesting because from a governance perspective, it seems like Ethereum is taking advantage of some of the lessons learned in Bitcoin and saying maybe we need more diversity in the client. Maybe we shouldn't have just one reference code. It has these nuances that speak to the core versus classic diversity issue in Bitcoin. And here Vitalik is saying that he would like to see 10% running the alternative one. To be clear, the Ethereum Foundation is responsible for managing Geth. So Vitalik is basically saying, I want the other people to get at least 10% of the network under these circumstances. Part of the reason for this is that Gav Wood created a pull request and merged it for the soft fork fix to the DAO hack first. So what Vitalik is saying, great, if you like this fix, run parity, and that's one way to get more diversity in the client. Taylor, what do you think of this move?
I think it's super smart. We should use this as an opportunity to have more client diversity. It's something that's been talked about for a long time, but as you've mentioned, Vitalik can't just snap his fingers and make the miners do certain things. They are using reference clients, but to date there are about 8 complete consensus implementations of the Ethereum virtual machine. So they're not all feature perfect with networking and so forth, but it would definitely be good to have something besides just one client running it. So when unforeseen issues pop up, we have a couple of options.
When George Washington completed his second term, he was asked by the American people to run again, and he refused. And he said, "I do not want to become a king upon the Americas," setting the stage for this idea of limited government and removing the possibility of personality worship. So hats off to Vitalik. He's following a great tradition by effectively pointing to the alternative choice and saying, you know what, we should be running a bit of that too. This is a great opportunity to do that, and it only increases my respect in Vitalik's general attitude by seeing this. All right, let's see what other questions we have. Here's another interesting point that someone brought up. You know, we talked about asset seizure under a hard fork, and a number of people wrote in to say, hey, but hang on a second. Under a hard fork scenario, doesn't the attacker essentially keep their ether? The only difference is they only keep them on a minority chain that isn't tradable anymore. So effectively, the hard fork doesn't seize the coins. It just moves the entire market away from trading those particular coins by putting them on a minority chain. Is that just legal sophistry? Is it really material to this conversation? It's a very interesting point.
Very cute. They call that legal acrobatics. Basically, if you are depriving this person of the benefit of their property, which you would be if you left them on a chain where they couldn't trade those for any sort of value, then the fact that they still technically own the coins doesn't change the deprivation of property. It doesn't change the analysis. But good thinking. I like what you're doing there. I want to jump in and say one more quick thing about solving this problem in the future. And I don't mean to talk again about the DAM project, but I'm going to. Because part of the concept of the DAM project was to provide software for people to implement in their own smart contracts that allows you to basically push a pause button and say, hey, wait, there's a dispute. And if that happened here, you could effectively have a solution that was based solely within that contract, and you wouldn't necessarily have to go out to the entire Ethereum network for resolution. You could use things such as maybe a mediation DAO to decide, or maybe you could use something like a DAO token holder vote that decides whether or not the hard fork internally, the change is going to be made within the smart contract. So it wouldn't be a hard fork necessarily of Ethereum itself. It would be a change in the state of the contract based upon some sort of dispute resolution mechanism that you put within the smart contract itself.
So we're still getting a lot of feedback from the audience. This has been a very long marathon level live broadcast, but we still have more than 500 viewers, and the numbers are still increasing. Hashtag LTBDAO on Twitter to ask a question. I think we should continue taking the questions for quite a while. Kenny asks, would informally verifiable code go a long way here? So one of the criticisms that's being levied is that the very concept of using imperative codes for smart contracts. Imperative means procedural language like Solidity that leaves a lot of room for interpretation, and because of it, the complexity of the execution path through the code can create all kinds of unanticipated behaviors. Kenny is asking, would informally verifiable code? A lot of people have made this similar suggestion. They've talked about using an abstract state machine or a much more limited but still Turing-complete language to describe the code. I think probably the horse has already left the stable, and the idea of trying to retrofit that kind of feature is moot. But do you think this was a problem of imperative code, and the uncertainties introduced by concurrency that could have been fixed by a formal language, or is that really just bike shedding?
I
Taylor,
think it's bike
you're the
shedding in the
technical
end.
guy. You have to answer this one.
Yeah, it's definitely, I think, a bit of bike shedding. I think it would be nice if we had all these tools, but it's just so early. We've got to build them out over time, and when we see these problems, we have a clear direction of what to build. But to say we should have gone back and done this in the past is a bit hard. There's lots of efforts for verifiable code, and I only look forward to having more tools to apply these situations to make sure the contract does what we intend it to do.
I would make the argument that if you want a limited and focused language for executing smart contracts, that is exactly the niche that Bitcoin occupies. And it has significant limitations in the types of smart contracts it can run, but it can provide a much more robust opportunity for security, or a much more robust model for security, if you want to run things that are much more flexible to explore all of the possibilities for innovation. Then you have to exceed those boundaries. And this is exactly what I mean when I say that Ethereum and Bitcoin occupy two different niches. And that's okay. You know, Ethereum is much more innovation focused, and Bitcoin is much more conservative in its security model. I think there's perfectly enough room for both of those models to coexist, and to try to say, well, we shouldn't do a fully Turing-complete imperative language in Ethereum and use only a formal language, well, that kind of regresses it back to the kind of limitations that Bitcoin already has, and we already have Bitcoin for that.
Yeah, absolutely agree. It's good to have multiple options. Not just for different economic perspectives, but also for different ideals of what you can accomplish in those. There are lots of experiments of many different altcoins. Not all of those have lasted, but it's really great to have a space that's growing in capacity and for different kinds of ideas and different tests. So it's just good to see everybody growing together.
All right, we've got a number of questions, still more. Let's see. Do you think a hard fork or soft fork could take the value of Ether to zero? Let's do a panelist poll. Brian, are you still here with us?
I am here. I don't know. It depends what the hard fork was, right?
Yeah.
I imagine Ether could go to zero any day for any other number of reasons. So I guess, you know, yes, possibly.
My theory is that
technical
very
person.
few currencies actually go to zero. You can still buy Roman sesterce in Rome. Hasn't been in circulation since 800 AD, and it still has a value that is greater than zero, but close to zero, possibly.
Yeah, but at least you can hold that in your hand, right? And this is the argument. I don't think it's going to go to zero. I mean, I think it's possible that it can go very, very low, but I don't think so. I think there are a lot of people really, really invested in this ecosystem, and I think that there's a lot of people that are working to make sure that that doesn't happen. So, yeah, I'm optimistic.
I would say that, yes, it could go to zero if we implemented something that broke the system altogether. Whenever you're making a change, there is a risk that you're going to break things worse, and if that were to happen, that could certainly drop the price close to zero. I certainly don't hope that happens, but there's always that remote possibility.
Would you consider participating in a future DAO, and would you consider owning ETH at this point?
I own ETH now, and I'm still a little bearish on the DAO situation. I don't hold any tokens. I don't intend to hold any in the immediate future, but certainly a DAO 2.0 would interest me.
Brian?
I mean, it depends on what the DAO was. I mean, right? I mean, I wouldn't probably jump into one tomorrow, and I didn't buy any tokens in this one, so I think it probably just depends. I mean, these are questions that are open-ended in that sense. I mean, you know, it's all about what what it's set up to do and what its protections are, and what your risk sort of how much risk you want to take on.
I agree with both of those. I have Ether now, and I'm very interested in these alternative governance models. I think it's fascinating. I'm very interested in changing systems and providing alternatives for what we know now is the status quo. So I'm very interested in the DAO and also other DAOs and DCOs and all these other things. So I would probably participate with the caveat that I would need to understand the risk profile pretty well.
All right, I have to say I own Ether, and I probably would sign up for another DAO. And my rule of thumb is I would take the amount of Ether I have, divide by the line number of code in the new DAO. The greater the number of lines of code, the less Ether I would invest in it. Because I think one thing that has been clearly demonstrated here is that complexity is the enemy of security. Honestly, I think the original DAO code, the whole mechanism of splitting and the way of getting refunds or withdrawing money from the DAO through the process of splitting in itself was overly complex, and something a lot more focused, a lot more simple may have avoided some of the security risks. Then again, it may have not. So we'll see. Question for the lawyers. What is the meaning of the term clean hands doctrine as used in U.S. law and specifically U.S. patent law? Does this apply here? Is this of relevance here?
Well, I'm going to guess and say that the clean hands doctrine is typically what that means is you won't get a remedy in equity if you're also guilty. So if you've done bad things and you're saying, oh, this other person has done bad things, a judge may not say, okay, we're going to make this right. They may just say, you know what, you don't have clean hands. We're not gonna deal with this issue. I don't know how that relates to U.S. patent law, and I don't know that it's directly applicable here because I don't know how legally we would get there to the clean hands doctrine and not enforcing.
All right, we've got another question. At the moment, the DAO is 0.06 ETH, and yet Ether is worth, what is it, 14 or 12? I haven't looked at the latest price. I'm going to pull that up right now. But there's a significant discrepancy in the price of Ether and DAO. Part of that represents the risk of running a split proposal under the current circumstances. All right, yeah, Ether is trading for about $11. The DAO is trading for about $7.50. There's a significant discrepancy. One way to describe that is as an arbitrage opportunity with obviously very significant risks. Do you think there are people out there who have enough of a risk appetite to go buy DAO tokens right now, hold on to them, hope for a fix in terms of a fork, and then do a split proposal and get them out in Ether and make a 20% return? Anyone?
It's hard for me to imagine anybody buying in the DAO right now.
But, and yet, Brian, the price wouldn't be where it is if people weren't buying into the DAO, because there's lots of people selling, so someone's buying. Maybe it's the attacker trying to short the position. That way they get a good result on both sides of the soft fork result.
Yeah, maybe it's just bots trading the market, trying to provide liquidity.
All right, we have a whole bunch of questions about Monero, which I am going to promptly ignore as off topic, and once again trying to push Monero. Question for Taylor: should a soft fork patch affect all transactions or only balance reducing transactions of contracts without code hash? I mean, how would you look at this particular soft fork? Do you think a more refined approach is needed?
It entirely depends on how many invocations of the DAO are out there, how many times people have deployed this contract. If we're talking about 1 or 2, our risk profile is relatively low, but you're still going to impact some people. I think a more surgical approach is definitely preferred personally, but there are different perspectives on that.
All right, question for the lawyers again. If meat space contract laws can be applied to the DAO, then what about FinCEN regulation of tokens?
Brian?
Do you think you
I
can
don't understand the question.
Do you think you
I'm
can
not
pick
sure I
and
understand the
choose?
question.
Yeah, I don't understand the question.
I think, and this seems to be a common misunderstanding, the idea that somehow if you float above the jurisdiction by not picking a choice of law, by not creating a contract or a registered entity, somehow this means that rules such as those applied by FinCEN or the SEC don't apply. So you can basically exempt yourself from the legal system just by making no claims as to coverage. To me, that seems to be a fundamental misunderstanding of how the law works. As far as I'm concerned, if FinCEN decided to claim jurisdiction over this, or the SEC, the only real issue is who would they sue first, or who would they try an enforcement action on first. And anyone who's not anonymous, anyone who represents like a target in such a case, would get targeted, regardless of whether you call the DAO an LLC, a general partnership, or a floating above the jurisdiction smart contract that doesn't subject itself to the law of mere humans.
Brian, you're the litigation expert.
Well, I think, in my mind, the SEC is the one that's most likely to feel like they have jurisdiction over what's happening here in the U.S., not FinCEN. But I don't know that for certain. And I would think that it's very likely that there are regulatory and law enforcement agencies looking at what's happened here. I mean, it just seems it's in the front page, not the front page, but it's making big news. There's a lot of money that's been, at issue here, and it wouldn't surprise me at all if that was happening. And the way they usually do things is they investigate, not bring an enforcement action right away, but usually investigate to try to figure out what happened, who there is to blame if they want to blame somebody, and if, frankly, sometimes they have to figure out if they have jurisdiction. In the SEC, the first question they ask is this, security? And try to figure that out. And if it's not, then it's someone else's, another agency's issue, not theirs. So I think, those are questions those agencies would have to grapple with. I think just because you don't call something a security doesn't mean it's not a security, obviously. I think that was Andreas's point.
Well, and even if you try to limit jurisdiction, you can't limit regulatory bodies. You can't say the SEC doesn't govern this contract. If the SEC determines that you've issued a security and they want to assert jurisdiction and they can rightfully do that, then you can't contract around those sorts of things.
Yeah, you'd have to go to them in advance with a no action letter and say, hey, here's what we're planning on doing, and if we do this, please confirm that this wouldn't be covered by SEC regulations, essentially.
I'm just waiting because the thing that I'm worried about the most, honestly, is not the SEC, is not FinCEN. It's Preet. Preet Bharara, Southern District of New York, has now stuck his fingers in every cryptocurrency-related investigation because apparently he can't find his way to Wall Street to check out some real crooks. So what he's doing is padding his resume with all of these digital currency prosecutions. I would not be surprised in the least if we see Preet show up in this space anytime soon and try to create a case regarding fraud or some other thing in the particular case of the DAO. I hope that's not.
Yeah, I mean, the basis for doing so is, the basis for launching a grand jury investigation is the hurdle is very low.
Ham sandwich.
Well, that's for an indictment. That's the phrase, right?
Yeah.
You can indict a ham sandwich. But this kind of thing, prosecutors read papers too, and they say, hey, that's interesting. There's $50 million, disappeared according to this article. What's going on there? I mean, and then they can start an investigation. It's really that simple, almost. So yeah, it wouldn't surprise me in the least if a U.S. Attorney's Office, or more than one even, frankly, have their ears perked up a little bit for what's going on here.
But I'm sure Preet Brar will be dissuaded by the fantastic argument that the DAO floats above his jurisdiction. Let's see how that works out. A lot of people are going to start feeling like ham sandwiches, I'll tell you. All right, I think we have covered all of the questions from the audience, and this has certainly gone on long enough. Thank you so much for the analysis and interpretation. Our first guest, Pamela Morgan, CEO of Third Key Solutions, an attorney and one of the people participating in the proposal of the Decentralized Arbitration and Mediation Network. Brian, I'm sorry I forgot your last name.
Well, I remember it. It's Klein.
Brian Klein, thank you so much, Brian.
It's your second beer. That's what I'll blame.
Yeah, blame it on that. That's probably a good bet. Brian Klein, who has represented people in many Bitcoin cases, including Eric Voorhees, Roger Ver, and others, and was also legal counsel for the Bitcoin Foundation as a volunteer for a while and has a lot of experience in this space. And of course, Taylor Gerring, co-founder of the Ethereum project, involved in both Bitcoin and Ethereum for many years now, and one of our favorite technical experts. This has been an episode of Let's Talk Bitcoin, a live episode with question and answers from the audience. My name is Andreas Antonopoulos. Thank you for joining me today in the DAO, the fork, the fallout. That'll be all. Take care, everyone.